What if I told you that private debt bonds can be used to offset public debts and that the wealthy have been doing this quietly for years? Now, in this video, I'm going to break down the concept of using private registered bonds, how it works, the laws that support it, and why it's one of the most advanced strategies in debt settlements. Now, I've studied administrative remedy, UCC, trust law, and the mechanics of private and public finance, and I'm here to show you how the elite play a completely different financial game than the rest of us. Now, before we dive into this video, this is not legal advice. This is not financial advice. Remember to do your due diligence. Don't just go based off of trust. Actually find the truth for yourself. Everything that I'm talking about here is things that you can look up online, and I'll even go to the Google reference, show you how I look it up on Google, and you can be able to look it up for yourself and get the context for yourself. Don't just go based off of what you hear in this video. Actually research everything that I'm talking about, okay? I do not take any liability. If you watch this video, attempt to employ this strategy without doing your own research and then not getting the results that you want. So my goal is to cover all of that in regards to private bonds, negotiable instruments, and how to be able to tender them as a form of performance with your debt contracts and how to settle your debts. You dig what I'm saying? If you also got here for the first time, click the like button. Go ahead and hit the subscribe button. Remember to tap into the community. Down below, I have a free Discord where you're going to be able to get updates on YouTube when I go live on Twitch. When I have any live event, you'll be able to have access to it and be able to tap in with the community and get your questions answered, give video ideas, connect with other people that are also exercising these remedies. Tap in with the Discord. The link will be in the description down below. Now, once again, thank you guys for watching this video. What we're going to be covering, you kind of want to make sure you stick all the way to the end, okay? We're going to be talking about the understanding of public and private debts as it pertains to debt discharge. We're going to talk about what a private registered bond actually is in its relation to it being a set-off instrument. We're going to talk about how to properly put that together and how to issue it as a creditor. We're going to talk about the legal merit behind it, essentially what makes it lawful. We're going to talk about the setup and how to properly put this together so that you can be able to get remedy from your private set-off bond, okay? Now, there are some extra steps that you may need to take. This is going to be very different from other debt discharge concepts. Yes, we may be talking about the aspect of you having a level of trust in order for this to work more securely and give you the most legal distance. But understanding this fundamental concept is going to be able to help you in this totality of debt discharge and communicating with debt collectors and understanding the truth behind what is really happening, okay? So make sure you stick all the way to the end because we are dropping some key game that nobody is talking about. So let's just talk about understanding the aspect of public versus private debts, okay? Public, when you think of the debt system, is based off, or the public is more of a debt-based system, okay? So when you think about you, your SSN, your straw man, there's all things or statuses that are being seen within the public eye. Okay, people can access it, you know, people ask you for it or whatever the case may be. Any debt that is tied to your SSN or your straw man or you is considered public debt. But then if we talk about the private debt, which is more on the creditor side, we are talking about secured parties. We're talking about a trust. We're talking about asset-backed instruments. Okay, now we're having a private conversation, or we can have a private conversation. Okay, so typically, all public debt must have corresponding credit. And the question is, who supplies it? So we can go to the definitions under, or the foundations under UCC 1-201, where it breaks down the definitions under the general provisions of person, security, if you wanted to particularly learn about the legal lease and the terms. But then we could talk about what truly qualifies as a negotiable instrument. Now, a lot of people don't know that what qualifies as a negotiable instrument is, this is what qualifies as a negotiable instrument. A negotiable instrument would be Except as provided in the subsections, negotiable instrument means a unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it, okay? The key word is a unconditional promise or order. It doesn't necessarily say that a negotiable instrument is a dollar bill, okay? It says a fixed amount of money. The definition of money doesn't inherently mean the dollar bill, okay? There's also United States money, currency, whatever the case may be. But the key word is a unconditional promise. So when it's unconditional, that means under no conditions, this is my performance. This is my promise, okay? Cannot be changed, all right? It says payable on demand or at a definite time, okay? So long story short, a negotiable instrument is a financial asset to the bank, okay? So when you go and you look at what a private bond is, a private bond, private registered bond is a private registered bond is a debt instrument where the bondholder's information is kept on record by the issuing party. This differs from a bearer bond, which relies on physical possession for ownership. It has no record of the owner's information. Okay. The key word is a debt instrument, and a debt instrument also falls under the category as a negotiable instrument. You understand me? So gathering these concepts here is going to help you to be able to, in its totality, use a private register bond or be confident in a private register bond. Now, if you don't know what a private register bond is, I mean, you can go to PDF Filer. They have this on there already. You can create your own private register bond for set off. But long story short, to show you what it looks like, and you can look this up, private register bond for setup on Google. It says a value $100 billion. I'll be very careful on how you do this. You know, again, this is part one. I will make a part two to this video. But as you see how it's broken down, address, we know these things. Obviously, you want to fill it out as a beneficiary. Enclosed undersigned John Henry Doe here, except for value, the enclosed bond certificate of live birth number. All endorsements front to back being the only legitimate acceptor of said bond, being the only party to have any value into said bond, being the contributing beneficiary of the same, in this accordance with the Uniform Commercial Code, House Joint Resolution 192, UCC 1-104, and Public Law 7310. Please deposit this bond onto the account using the USPO, registered mail number, blah, 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 information. Please adjust any bills, claims. And as you can see, if you go on here, this is essentially a promise or order to pay a fixed amount of money, okay? So just understanding that fundamental concept, okay? And understanding that a negotiable instrument can be created in multiple ways. Whether you create a bond, whether you decide to create a promissory note, whether you decide to create a order and put it on bond paper, that can also, as long as you sign it, it becomes something that is a negotiable instrument, something that can be enforced, something that a bank can essentially make money off of. All right. Now, everything in the public is prepaid, and you're just not the party presumed to issue credit. They assume that you aren't the one issuing credit. They presume that they are actually loaning you money. But the reality is that they're not loaning you money. They really can't, okay? When you're operating privately, you step into the role of the creditor, and that changes everything. This is why you want to go private, or this is why you want to start communicating from a private perspective, because let's just say you don't do any communication, you just go in a court of law and try to have a public argument about these concepts. They're going to treat you as a debtor. They're going to treat you more in a public sense. But when you do that private administrative process and you're saying your status as a creditor, they have to treat you as such or debunk it. Okay. So back to the private register bond. The private register bond is a negotiable instrument that you would create and register privately, often through a trust or an estate. So this wouldn't work if you don't have your trust set up. So you got to be very strategic when you're doing this and make sure you have the right trust set up. It's backed by a private credit. not public funds. So the trust is truly going to come in handy in this aspect. And it is used as a set-off instrument when issued properly under contract law. Under contract law, there's an offer and acceptance. This would be considered an offer that they can decide to accept or refuse. Now, if they decide to accept or if they decide to refuse this, the beauty about the law is under UCC 3-603, tender of payment. It says this is a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, and the tender is refused, there's discharge. So it's almost like what we're planning to do, regardless if it works inherently, my debt is going to be discharged as long as I send it in. These are the concepts of discharge that people don't understand. They think that, damn, if I send this, they're gonna tell me it's discharge. But no, the game is much more deeper than that. The conversation is probably gonna come more on the aspect of if they are adhering to a contract, if you are performing. Okay? So when you think of the process, and this is more of a high level overview of the process. So when I say high level, it's just going to be something I break down really fast. Only the people that are there will get it. And I may create a separate video breaking down how to do all these extra steps. But looking at this, number one, you want to create a bond as a creditor. So the thing that I just showed you, you want to create the bond as if you are the authorized officer, the creditor, or the trust. Okay? You want to register it privately, notary, via a notary through UCC or a trust record. You want to present it to a public entity to settle the claim or a debt, the public entity being the credit company, whatever the case may be. Also, you want to, if you are going through a trust, you want to make sure to assign the debt to the trust, then create your private bond as the creditor, and make sure you address it to the public entity that says that you owe a debt. Some of the laws that back up this process is E3-603. Obviously, you're creating a negotiable instrument that you can enforce. And if it is refused, there's discharge to the extent of the amount of tender. So if it's a $30,000 debt and you tender a $30,000 valued private registered bond, and of course you want to send this registered, okay? But you issue a $30,000 bond and they refuse it, then that $30,000 should be tendered and discharged. Then we go to UCC 3-104, which is a negotiable instrument, means a unconditional promise or order. Then we go to 12 USC 411, which talks about the issuance of Federal Reserve notes from Federal Reserve banks. It says that all notes shall be obligations of the United States and shall be receivable by all national and member banks and Federal Reserve banks for all taxes, customs, and other public dues. We can even go to 31 USC 3713, which essentially talks about the priority of government claims. Long story short, it says that if a person owes debt to the government, then the government debt should be prioritized over any other types of debt. Okay? So you can use this in your argument. I'm not saying this is the argument that's going to be completely solid, but you can use this in your argument or as an advantage. Hey, look, I owe the government or the IRS, so you guys aren't my priority. Okay. And this is a gem that nobody truly talks about, 31 USC 3713. Okay. So now just looking at a couple of those laws, and even if you look at House Joint Resolution 192, there's proof that there's no lawful money and all debts are discharged, okay? And I want you to understand that this isn't about getting something for free. It's about returning credit back into the system to balance the books. It's a accounting thing. It's an accounting entry that needs to be done when it pertains to debt discharge and debt collection. A certificate of indebtedness needs to be submitted. A bond needs to be paid for or issued. So let's just talk about what makes everything that I'm talking about lawful. Okay, there's a difference between legal and there's a difference between lawful. Something that's legal is more on the commercial side, more in commerce. Lawful is more about your person, more about equity, more about trust. And law is greater than legal. Okay, so there may be a chance that some of these things aren't all the way legal, but it's lawful. Okay, and lawful supersedes the legal side, but you have to make sure to bring the conversation around the lawful aspect of things and keeping it out of the legal. Okay. And that will come important when you are, depending on how you address the creditor or address the opposing party. Are you going to address them as a creditor? Are you going to address them as a trust? Are you going to address them as the debtor? Okay. So what makes this lawful? Okay. Number one, in order for the bond to work, there must be an agreement and a contract. Okay. Typically, people try to use these bonds to get a brand new car, whatever the case may be, but that doesn't work. You need to already be in agreement or a contract with the company that claims you must perform by paying a debt. It must come from the proper party, a secured party, a principal, or authorized agent. You will technically be the secured party, the principal, or the authorized agent. You want to notate that in your affidavits. The instrument must be complete, non-frivolous, and backed by value or consideration. The consideration is your signature. Your signature pretty much gives it the value that is stated on there because that's what a negotiable instrument is. But what happens is that we can't prove the consideration. So let's just prove the consideration real quick. When we look at a negotiable instrument, we understand that that's a financial asset to the bank. But if we look up signature in Cornell law, and that's UCC 3-401, under UCC 3-401, it says that a person, long story short, breaks down the fact that your signature is what creates the obligation, okay? And the obligation is the financial asset, all right? So, and yes, that may be hard to argue in some cases, but that's the consideration, your signature, giving it the value. You can even break down modern money mechanics. Modern money mechanics breaks down the value of your signature and how you are the one that creates credit, or they're able to create credit out of thin air because we put in loan applications. All right. Now, here's when the remedy is often rejected. When it's sent without notice or contract, you must put them on notice and say, hey, look, this is my tender of payment and I'm using this to tender my bill. Also at the same time, when there is no trust structure or power of attorney established, if you're planning to do this, it's best if you do it through a trust. It's best if you communicate with them from the creditor side versus the side of a debtor. If you're going to do the private bond, okay? And the bond is unregistered or improperly executed, okay? You want to make sure to properly register your bond, okay? You want to make sure that you execute it properly, okay? Supporting doctrines that you can include is your right to set off. That's under banking law. You can look at the creditor priority under commercial and bankruptcy law. And you can also look for the aspect of constructive trust and equitable principles. Common law and contract law, can be used hand in hand with the UCC and cover up some things that the UCC doesn't cover, like fairness, like coercion, or things that is not really explained in the UCC. Okay, so the law allows it, but it requires precision, intention, and the correct status. The correct status is going to come from whether you communicate your status, or it's going to come from whether you communicate your status or whether you do it in the public and you have it on public record. Okay. Now, we're going to talk about the proper setup of using a private register bond. Okay. Before issuing a bond, you want to make sure to secure your status using a UCC-1 financing statement and creating your trust and essentially assigning your straw man and estate to your private trust. So how you would do that is you have to have that private trust in place. When you have that private trust in place, you do your UCC-1, make the trust the secure party, and you and your straw man is the collateral. Okay, your birth certificate is the collateral. Okay, you assign your straw man and the estate to your private trust. After you do that, then you create the bond, include the date, the amount, the parties, the consideration, the purpose. All this is laid out in that online example. Register it privately, log it, add the trust minutes, notary ledger, or any of the UCC filings. This is what you need to do before issuing the bond. Then when you issue the bond, you want to then submit a conditional acceptance or a notice of tender. Conditional acceptance is saying, hey, please provide a proof of claim that I owe this, and then I'll agree to pay. Versus a notice of tender is putting them on notice that this is what you're using to tender your performance. You can include things like an affidavit of truth or IRS forms if applicable, or any type of mailing proof. And an affidavit of truth is your statement of facts. You want to state that you can use this. You want to state that this is a negotiable instrument. You want to state that if anything that they say, anything that doesn't go unrebutted is something that will stand in truth and law. You would say things like that in your affidavits so that they know exactly what it is that you know and what you expect out of them. So when they do send you a letter and they don't give you what you asked for, now it's them maneuvering in a way that is not proper. Okay. And then give them time to respond or rebut. Okay. They're going to respond. If they don't respond to you, pretty much follow up with them, just like you will follow with any other. If it's an interviewer and they don't respond, you follow with them a week later, right? You want to do the same thing with them. You want to follow up with them. Ask them about the bond that you sent them. Ask them if they received it. Let them know, hey, I sent it certified or registered. I got the notification that you guys received it, and I haven't gotten a response. I'm going to assume that you missed it. So here is my second attempt of sending it to you. You know, follow-ups like that. And then doing things like when they do rebut or they do respond, looking for whether they accepted it, looking for whether they rejected it, and calling them out on their rebuttal. Okay? If they say something that is not true, you challenge them on it and you say, hey, no, that is not true. Can you prove that to me? Okay? So your paperwork is a transaction. If you don't do this, reference or make it lawful, it technically didn't happen in the law. So this is why it's important for you to have a administrative record, written record, and pretty much a paper trail before you or while you're doing this in order to enforce it. If you don't, you can't really enforce it. So I know this was a pretty quick video. I wanted to break down the private registered bond and how you can use that as a negotiable instrument only if you are going to do it from a trust perspective. If you're using a private registered bond, it's one of the most advanced forms of remedy, and it's not for beginners. This is for my people that's on the right frequency, that's been doing this for a while, understands trust law, understands contract law, and has a real understanding of public and private jurisdiction. This is not for people who are brand new to private and you know, still in the allure of sovereignty. This is for people that's already in the thick of it, that just need more clarity and understanding. It's still important for you to understand the administrative process. It's still important for you to be able to communicate with a debt collector. And lastly, if you are here and you say, well, damn, I was looking for something, my status isn't corrected. It's okay. There are debt validation. There's you challenging whether the account was securitized. There are things when you can use conditional acceptance. There are things when you can be able to, you know, you create your own negotiable instrument and enforce it. These laws still apply even if you decide not to use a private registered bond. If you want to learn more about this, down below is my school community. It's only $1 a day. Depending on when you see this, it might be on a free trial, 7-day free trial for all my people that want to get tapped in and see what it's like. The free trial will be there. Tap in with the school community if you want the resources, the templates, and the course. Okay. Number 2, if you want to work with me one-on-one about your credit, funding, or even starting your own credit repair business, tap in to apply my one-on-one mentorship down below. Follow me on Instagram at biz.nick. Follow me on Twitch at biz_nick. We haven't been able to go live on Twitch for the past few weeks, but when I get back to Tampa, we're gonna go on like a streak of going live every day just for you guys. So remember to tap into the Twitch. Lastly, comment below if you ever heard of private bonds before. If you've already tried it, ever seen someone try it. Let's break the silence around the remedy, take the mystique away. And if you've gotten this far, remember to like, subscribe, hit the bell for the notifications, because I teach you everything that you don't need to learn, you know, and not what you need to learn. This is the page where you're going to be able to learn any and everything that you should learn towards the truth about this economy and how to be able to overcome it. If you've gotten this far, comment the word discharge, and I'll see you in the next one.